Hi there and welcome. In a couple of recent videos I have spoken about the very troubling absence of English law's required points of proof from Ms. Letby's 15 convictions. Today instead I want to talk about how the prosecution groomed, seduced and misdirected the jury from asking the questions on the points of proof that they should have been asking to accepting off-the-peg answers to entirely different and irrelevant questions as being suitable for deliberation on Ms. Letby's innocence or guilt. What the prosecution did in this case was to surreptitiously use the emotiveness associated with the alleged victims and the sheer psychological impact of attempting to get to grips with a tsunami of scientific information, in truth disinformation, to more or less bludgeon the jurors into that semi-shut-down mental state which is apparent in the victim of any serious injury or otherwise traumatizing event. With the jurors thus suitably incapacitated, the prosecution was in a position to quietly conflate the legal requirement for a specific evidence prohibited act with merely plausible concocted scenarios of how murder could have been done in the 22 circumstances. Concoctions which the jurors were reassured they didn't need to understand but could simply take the word of 7 experts they were unaware were either incompetent or professionally compromised on. That being done, the prosecution was then in a position to bring its bogus convictions home by means of something I have mentioned in my first video and should perhaps have taken the opportunity to expand on in the video I did on the apparently criminalizing but actually almost non-existent Facebook searches. The thing I'm talking about is the prefabrication of another required point of proof, the criminal mindset element, through character smears, insinuation and innuendo. Essentially a relentless damned if she does, damned if she doesn't approach to the interpretation of everything about Miss Letby's lifestyle, working preferences and general work habits. Expressing pleasure by text message to an unexpected, or rather for an unexpected grand national win at the end of a difficult shift is evidence of her serial killer heartlessness. Expressing concern at the future prospects of a particularly sickly baby is her serial killer wishful thinking coming out as behavior leakage. The prosecution thus complemented the concoctions masquerading as evidence of wrongdoing with character smears to generate sufficient malice against Miss Letby in the minds of the jurors such that it was natural for those jurors to conclude that if there were more dead babies than normal and there were essentially undetectable methods by which they could have been killed, and there was this hateful and weird person in their environment, chances are she probably killed them. That brings me to the original thought that motivated me to do a video on this subject. That the jurors were simply the 12 warm bodies that were needed to be emotionally seduced, informationally manipulated and administratively coerced at the death into making the required utterance on the 18th of August 2023. The 12 jurors were reduced to the required 12 warm bodies by newly lobotomizing them where the case was concerned through sheer information overload. The Crown Prosecution Service is a state agency with all the resources of the state available to it, including psychological research and psychologists. The CPS, therefore, well knew exactly how the human brain reacts to information overload. It shuts down. The more information they gave those jurors to wade through, the more intellectually dispirited and therefore malleable the individuals would become. I would bet big that if Dr. Shu Lee's dream team got hold of the scientific background information they gave to the jury, they would find that the majority of it was not necessary for an understanding of the science used in the various counts in the case. The obvious way to use information to mislead is to simply withhold it. The same objective can, however, also be achieved by passing the information, but passing it buried so deeply in irrelevant extraneous stuff that it is never reached, or if reached, is likely to be missed as a result of information overload. To see this more clearly, we need to look critically at the unusually long 22-month lead time between Miss Letby being charged and the case being brought to trial. We are led to believe that this was necessary because the case was so complicated, leaving us to speculate benignly that this makes sense as there were 22 counts after all, 23 if we include the one that Goss mysteriously saw fit to stand down before the trial. But there were not 22 different areas of science to explain to the jury. Even by the prosecution's own count, there were only 9 so-called methods of attack. Professor Shu Lee's team brought that down to 4, if memory serves me correctly. Those being 1, air embolism, 2, bolus of air to the stomach via the nasogastric tube, 3, insulin, and 4, either tube dislodgement or physical trauma or possibly overfeeding. Let's quickly run through them. Regarding air embolism, up to a revised publication in December 2022, the definitive research on the issue was a paper from 1989 based, I understand, on a total catalogue of only 57 known cases. Who among you would disagree that the principle behind air becoming trapped in the heart, thereby disrupting its function, could be explained by any science teacher to a class of 14-year-olds using the analogy of the knocking sound we sometimes get in our radiators because of trapped air? Who would deny that the sense of it could be conveyed by a suitably qualified, informed or experienced person to a layperson in a paragraph? This is basic material world physics, not esoteric science. It is plumbing. That the time was not spent making the primary research, Dr. Shu Lee's 1989 paper, accessible to jurors is evident from the fact that Dewey Evans, the architect, did not succeed in making it even accessible to himself, mixing up the telltale skin discoloration caused by air injected into an artery with air into a vein. Post-trial, he has openly conceded on at least one documented occasion that an aspect of the phenomenon which the interviewer had put to him was news to him, as he'd not been aware of it. It is therefore quite possible that he didn't even read Dr. Shu Lee's paper himself. So, the second one, bolus of air via the nasogastric to distend the stomach, thereby putting the lungs under pressure. Even if it was a practicable mechanism, is hardly rocket science. Again, who among you would dispute that the admittedly pseudoscience principle of filling the stomach with extraneous air in order to put pressure on the lungs could be explained even more readily to the same class of 14-year-old students with an inflated balloon as a prop for demonstration purposes? Regarding insulin poisoning, all that the jurors needed to know is that when the body produces insulin, it also produces a proportionate amount of C-peptide. In an otherwise healthy body, the amount we measure of one of them implies a ballpark figure of the other. This is to dip a toe into biology, but it is hardly high-level science. The fourth method recognized by the International Dream Team was, I think, to be one of, as I said, tube dislodgement, physical trauma, or the outsider overfeeding. Regardless of which one it was, because it's not really important, the only requirement for anything approaching science here would be to point out that the alleged harming principle with the overfeeding is identical with bolus of air, because the other two aren't science. Now, on top of what I've just said, information has come out since the trial that renders laughable the idea that the 22 months was spent in putting together the case in some more general sense either. Let me explain. If we make the assumption, an admittedly generous one, given the amount of wrongfulness evident in this prosecution, that the Crown Prosecution Service did not deliberately switch around the door swipe data in order to gain an advantage in the Child K case and the other 7 affected by it, then we are left with no other explanation than that of the most basic fail in bread and butter information management, information handling imaginable. Further, we have the farce of the Child C case, where it only emerges at trial that Miss Letby had not in fact come into contact with a baby prior to the all-important X-ray it is claimed shows the air that she was supposed to have introduced into the baby's stomach to harm him. Then we have Nurse Joanne Williams giving evidence to the court about the conversation in the immediate aftermath of Child K's collapse, giving the lie to the principal witness to the attempted murder, Jairam's evidence. In asserting that Miss Letby was the nurse concerned in the collapse, Jairam detailed questions he'd put to her. Nurse Williams, in her testimony, told the court that the questions referred to had been addressed to her, giving no indication of Miss Letby even being on scene. Finally, in the Child F case, the admitted gateway to all 22 charges, we have the farcical spectacle during the trial of the prosecution literally scrambling to cover testimony from the unnamed Nurse 1 that in replacing the long line, the drip line, at noon that day, the 5th of August, she almost certainly would have replaced the spiked TPN bag the prosecution's original case was, in this count, had been built on. Unbelievably, the relevant expert, Hindmarsh, actually sat there and gave the jurors 3 different possible scenarios to choose from which to conclude that Miss Letby had attempted to take the baby's life. The first, that the same TPN bag was used throughout this non-existent hyperglycemic episode. The second, a scenario where the TPN bag was changed at noon, as hospital policy and practice would dictate, but no one was able to confirm that this had actually taken place. And the third, where in that second changed bag scenario, sub-scenarios of 1, the changed bag being equally spiked as the original bag, and a second sub-scenario of the changed bag, the new bag, being a clean one, clean from insulin. It was just like a game of pin the tail on the donkey. The foregoing selection is based on having read only 5 of the Tattle Life court reports from beginning to end, those being F, G, H, K, and L. They account for only 8 of the 22 counts, 23 with the Child K retrial, and 4 of the original 14 convictions. As such, it is a fairly safe assumption that the 15 counts, including the retrial, that I haven't read through, would throw up similar instances of the left hand not knowing what the right is doing in the presentation of this whole case. The period from November 2020 to September 2022 was therefore patently not used by the prosecution to get their ducks in a row. If this 2-year period, more or less, was not used for information management, then what was it used for? Why did the Crown Prosecution Service need so inordinately long a lead time between charging and bringing the case to court? It's the longest delay between charging and trial I've ever heard of. My understanding was always that a suspect is only charged at the point where the police have sufficient evidence to secure a conviction. If that was the case in November 2020, why did the CPS have to wait 2 more years? The answer can only be that a conviction would not have been possible on the evidence available in November 2020, but nevertheless, someone made a decision that this case had to and was going to result in a successful prosecution one way or another. The time between charging and trial was therefore still dedicated to information management, but information management in a more sinister, Orwellian sense than the ordinary understanding of the phrase. As we now know, the jury was left in the dark about the fact and the very existence of the 2 autumn 2016 reports that were the basis of the original police decision that foul play was not a factor in the deaths and collapses. Those reports were, of course, done by the Royal College of Pediatrics and Child Health and by a senior neonatologist from the Royal Free Hospital, with a supplement to it by a senior pathologist from Alder Hey Hospital. Additionally to being kept in the dark there were at least 4 other sources that the jury could reasonably expect or reasonably be expected to have been made aware of, but were not. Those being colleagues who were supportive of Miss Letby, but were deterred from giving evidence, intimidated apparently. Secondly, experts who were convinced of more plausible explanations than murder for babies they believed to be to have more health issues than the prosecution told the jury. The third, some representation from Miss Letby's counsellor regarding those post-it notes. The fourth, the pathologists who didn't diagnose foul play in any of the 6 post-mortems undertaken on the 7 babies Miss Letby is now convicted of murdering. A reasonable conclusion then is that the period from November 2020 to September 2022 was a combination of both an extended SWOT, strengths, weaknesses, opportunities, threats, analysis around the achievement of the objective convictions, and the making of appropriate information handling decisions in order to maximize such strengths as had been identified, downplay the blindingly obvious weakness of a total absence of evidence, identify opportunities to facilitate the first 2, and finally identify and silence any threats, presumably nurses and junior doctors from the neonatal unit, and more than likely the authors of those 2 reports from autumn of 2016. The time was no doubt also spent deciding what a hand-picked judge would let them withhold, information-wise, and Where withholding the information was a bridge too far for even such a judge, what the options were for misdirecting attention away from that information. After the Birmingham 6 and Guildford 4 disclosure rules introduction, it didn't take legal professionals, congenitally slippery by nature for the most part already, very long to work out that more can be just as effective as less in circumventing those new disclosure rules. It is then the tiniest of mental steps to recognize that the same principle could be applied to other case information, like the benefit of throwing huge amounts of it at jurors. I will use personal experience of my own intellectual journey from ignorance to knowledge of one aspect of the case to illustrate the fact that generalized abuse of information was central to the CPS's prosecution strategy. Another thing, I cannot be as certain of this, but it may also evidence a concerted effort by all legal professionals involved in this trial to obfuscate information that would most naturally lead to Miss Letby's exoneration. You have to decide. The personal experience is my learning about the clinical concept of a T-pin or dextrose bag's long line having tissued. I went through the child F case for the first time at the very beginning of September 2023. The 4,000 word review I then did was originally published as a blog post on the Science and Trial website a few days later. 15 months later, I then used it as the text for my second very long video on the case. In the original review, I used the word tissued only once and made no attempt to say what it actually meant, because I didn't know. All I knew was it was the reason given by the nurse, unnamed Nurse 1, for changing the drip line between at noon on the 5th of August of 2015. 15 months later, in a quick scan of the original court report to double check a few things before doing that video, I was again struck by the numerous mentions of the word tissued in the report, always with quotation marks, but never any record in that court report of a word of explanation being given to the jury of any medical significance of such an occurrence to the case, or to the count. As I was potentially going to be speaking to a wider audience, I thought it appropriate to at least suggest what it meant. So I went beyond my original text, speculating in my video that tissuing must describe bodily fluid getting into the plastic tube, coagulating, and thereby blocking it. Obviously, since Dr. Shu Lee's presentation, we all now know that what it meant for baby F is that dextrose that was supposed to be introduced into his bloodstream flowed instead into muscle tissue, having no effect beyond fluid retention-based swelling. The closest to something of a hint in the court report of that was in the record of text messages on the baby between Miss Letby and unnamed Nurse 2, the designated night duty nurse for child F, on both the night of the convicted attack and the following night. Now, the relevant text sent to the off-duty Miss Letby sometime overnight from the 5th to the 6th of August 2015 is represented in the court report as follows. I quote, "The long line had tissued and child F's thigh was swollen," end quote. The words tissued and swollen were separately in quotation marks. I'm unclear who is behind, what organisation is behind Tattle Life, but the more I look at their court reports on the case, the more concerned I become that they are part of the cover-up. I won't go into that here, check for yourself if you doubt me, but the giveaway in this particular texted conversation is that whereas the majority of the huge number of largely irrelevant texted exchanges, which are all over the certainly the 6 reports I've read from beginning to end, they are generally verbatim, but this particular one is broken up and packaged such that only those with some medical experience or the very smart might make the connection between the two things quoted, rather than assuming that the texter was reporting 2 separate unrelated developments. I certainly wasn't smart enough at the time to make the connection, opting instead for the 2 separate things speculation. I could of course be bearing false witness against Tattle Life. Perhaps they reported these text message exchanges exactly as originally presented to the court, as you'd like to think they would. If that's the case, and as Tattle Life is the only freely available court reports, let us assume it is, it strongly supports my thesis that the prosecution was allowed to go far beyond merely presenting information in a favourable way to out-and-out abuse of information to secure the conviction of Miss Letby. I want to make 2 points here. The first is that no other mention of tissued in all the witness testimony and cross-examination in the report is in proximity to any suggestion of swelling. That was straightforward because nowhere else in the report is there a mention of the baby's swollen groin and right leg. That was information I picked up from some other source. The second point is that as soon as Dr. Shu Lee described what tissuing actually means, like many of you I'm sure, I had an immediate epiphany on why the hyperglycemic episode had persisted, even before Dr. Lee then went on to spell all this out. That would have been the same for all the members of the jury in that courtroom. As such, even with insulin poisoning as a conveniently agreed fact, I really don't think the stronger characters on that jury would have ever caved to the pressure to convict on the insulin if they'd had knowledge that, certainly in the child F case, that for hours on end, the dextrose had been going into the baby's groin and flowing down inside his right leg. That would be, in fact is, prima facie evidence of no hyperglycemic episode, and therefore no question of insulin poisoning to be addressed. In closing, I return to the core point of this video, my strong suspicion that the architects of Miss Letby's conviction simply required 12 warm bodies and abused the powers of the state to create that state of affairs. Yes, the agreed fact of poisoning, as Goss no doubt reminded them in his intervention after the initial 13 days of deadlock in their deliberations, meant they had no choice but to convict on the 2 insulin cases. But, I ask you, what other explanation than total suspension of rationality can account for later convicting baby C, for example, after the red flag of Evans changing his mind as to the method of murder during the trial, in the process making a liar of Johnson KC in what he had previously told the jury? Okay, so that's what I wanted to say. Feel free to, as usual, share your comments, share your thoughts rather in the comments and any information you think might be of interest. Thank you for watching as ever, and thank you for your time, and all the best.